Thank you, Mr. Chair. And how interesting that we've just had Mr. Parakura Haumea talking about the virtues of one law for all, and Tau Hanari saying what's wrong with that. And you'd believe, sir, with that interjection, that Tau Hanari actually believes we should have one for law, and that actually highlights, Mr. Chair, how Tau Hanari doesn't even understand this bill. Actually doesn't understand the detailed provisions of this bill, sir, because one of the clauses we're actually debating is clause 93 in this fourth part, and that clause actually restricts iwi and Hapu, Mr. Hanari, to bringing claims within 6 years. Why should iwi and Hapu have their ability to bring claims within 6 years restricted, or their ability to bring claims within 6 years restricted, sir? And that's just one example. That is just one example of why we don't have one law for all. It's just one example of one of the provisions that is actually bad for iwi and Hapu. Now, I can actually point to a number of provisions that give iwi and Hapu benefits that other New Zealanders don't have. But equally, Mr. Speaker, in that clause 93 in this fourth part, it's actually a clause there that takes away, Mr. Speaker, from the rights of iwi and Hapu. Mr. Speaker, in this debate, and I have a number of contributions I'm hoping to make on this part 4, I do specifically want to focus on clause 93 and clause 105. I also have a number of amendments, or rather my colleague Hilary Calvert has a number of amendments, and so a number of them are very substantial and actually make substantial improvements, sir, to this bill and the provisions. But before detailing those amendments and before, sir, coming back to those clauses 93 and 105, sir, I just need to very briefly comment on the comments from Honi Harawira. Honi Harawira has used this debate, sir, as a continued opportunity to take shots at the Maori Party. And Mr. Chair, I need to repeat that this bill is a victory for the Maori Party. It's a victory, and I think you can see that, sir, in the fact that 200 people are marching towards Wellington and Hikoi, where 7 years ago there were 40,000. And so there may be a perception that Maori don't support the Maori Party on this bill, but I believe over the next 7 months, as the Maori Party gets out and gets into the community and explains the massive benefits, notwithstanding that 6-year restriction that I just referred to, I have got no doubt that the Maori Party will build on this support, and I've got no doubt that they'll be returned to this Parliament, sir. And I think one has to look no further than the article published in the New Zealand Herald last Wednesday, where Tariana Turia and Peter Sharples make the point for all the benefits they have achieved, and they conclude, sir, by saying, make no mistake, the Maori Party persuaded the National Party to support this bill. We will work with any party that supports kaupapa of our people. For a small party, we have achieved amazing results in a short time.
Point of order, the Honourable Parakura Haumea.
Mr. Speaker, I think one thing that is important is to ensure that our language is pronounced well. And he said kaupapa. It is actually kaupapa. Ko as in toe, pa as in pa, papa. Kaupapa, not kaupapa. Kaupapa.
I want to thank the member. I'm sure that we all can improve our pronunciation of the Māori language, me included. And I just want to say that to the member with the deepest respect, in the strict ruling of this House, the kawa of this House, that is not a point of order, but it's helpful.
Thank you. Sorry.
I call the Honourable John Boscawen.
Thank you, Mr. Speaker. And what the ACT Party, and I've got no doubt the Labour Party, have tried to bring to this debate, sir, is a debate based on ideas, Mr. Speaker, and on arguments. And, sir, it's been very, very sad to see this debate cast as a racist debate in the media. And, sir, I particularly found it sad when just half an hour ago, Tariana Turia, alongside me, and Rahui Kātane, made the comment when responding to David Parker's submissions. She said, no, because you're a bunch of racists. No, because you're a bunch of racists. Sir, I heard those words myself just a few feet from my seat, and I found those comments actually very sad for someone who has achieved so much for Maori, Mr. Speaker. So let me turn now to Clause 105. What 105 says, sir, is it says that to bring a claim for customary title, it is not actually necessary, sir, for iwi and Hapu to actually bring that claim or to prove that claim. In actual fact, sir, it reverses the burden of proof. It actually says that those customary interests are deemed to exist unless proven otherwise. Those customary interests are deemed to exist and prove otherwise. In other words, Maori, iwi and hapu have a customary interest in the foreshore and seabed, now renamed the Common Marine and Coastal Area, unless proved otherwise. Now, we heard from the Attorney General, who said, well, there's nothing wrong with that. That's no big deal, because that is the situation in Canadian and Australian common law, and we're doing nothing more than what has already happened. Well, sir, either the Attorney General is trying to mislead New Zealanders, or he actually doesn't understand his own bill. And I suspect he does understand his own bill, although I believe there's a very large proportion of National Party MPs. Mr Chair.
I call the Honourable John Boscawen.
Sir, this section 105 is very important, because in 1840, Maori customary interests, iwi and hapu customary interests, sir, went out to the 3-mile limit, went out to the limit of the territorial seas. And what this bill Mr Chair, is doing is enshrining in legislation a customary interest that goes beyond that 3-mile limit out to 12 miles. It's creating customary interest, sir. It's creating a customary interest, and it's then up on the Crown to prove that customary interest doesn't exist, sir. And, sir, if you doubt the importance of the massive win that clause does, and the massive transfer of wealth that will create from all New Zealanders to just some New Zealanders, Mr Chair, you only need to look at the speech that Tariana Turia gave in this House on the second reading. And if you look at Tariana's comments in her Hansard, she says, there is also a very interesting provision tucked away in Clause 105, headed up Burden of Proof, which states explicitly, it is presumed in the absence of proof to the contrary that a customary interest has been extinguished, end of quote. In other words, Tariana Turia says, it will be up to the Crown to prove that any interest has been extinguished, rather than the onus of proof being placed on whānau, hapu and iwi, sir. So what this bill does, sir, this creates a customary interest, the ability of iwi or hapu to claim a customary title over land to the 12-mile limit, sir, the territorial seas, a limit that was only just extended less than 40 years ago, Mr Chair. Sir, coming to the Clause 93, the ACT Party campaigned very strongly for the tightening up of this provision. We've said to New Zealanders that this bill, the provision as it came to the Parliament originally, provided, Mr Chair, for Order in Council to give effect to an agreement on customary title. Order in Council, it didn't actually have to come back before the Parliament, and to be scrutinised by public scrutiny. Now, sir, the government has moved on that. They have made this change, sir. You might be inclined to ask why. You might be inclined to ask about the quality of the scrutiny that Parliament would give, sir, because we saw that the Maori Select Committee's scrutiny of this bill was very poor, because the 520-page officials report and its recommendations were dismissed in an hour and a half. But nevertheless, we have that scrutiny. So that is at least something to be grateful, sir. And that is important, Mr Chair, because the provisions of this bill are very, very wide-ranging. Sir, if you look, for example, the attorney has focused on the issue of access, on free access. Sir, I wonder how many boaties are aware of the provisions of Clause 28 that will be incorporated into those agreements to be scrutinised by Parliament. For example, if you're a boatie, you are allowed to temporarily anchor, moor or ground your boat. You're allowed to remain in place for a convenient time. Well, what is a convenient time for a boating? What does temporarily anchoring your boat mean? Does that mean you can anchor your boat for 1 hour, 3 hours, a day? At what stage do you overextend your welcome and a customary title can actually charge you to moor your boat? We don't know, Mr Chair. The courts don't know. The courts are going to have to find out, and the Attorney General has the audacity to come into this House, sir, and it creates certainty. What this bill, sir, doesn't create certainty. So I want to move now to some of the amendments that the ACT Party is putting up, and there are several amendments, sir. There is several hundred. There have been several hundred in total, Mr Hanari. And what a disgrace that we're actually in this House last night after midnight after midnight, voting on this bill, voting on the Attorney-General's amendments. And interesting, sir, that we're actually voting on the Attorney-General's amendments, because if he had followed proper parliamentary process, we would have actually had that in the Select Committee, the very Select Committee that Mr Hanari chairs, and as an animal, sir, as a person, all he can do is simply sit there and bark at me, Mr Speaker, sit there and bark, and if he had actually chaired a Select Committee, Mr Chair, if he had actually chaired this committee properly, Mr Chair, and actually showed some leadership, we wouldn't actually been sitting in this House after midnight, Mr Chair, voting on the Attorney's amendment, sir. They would have been properly included in the report back of the Select Committee. So let me move to the first of the major amendments the ACT Party, or Hilary Calvert rather, is moving, and it's amendment to clause 118, subsection 1. Mr Chair.
Call Rahui Karne.